Tuesday, I was going through emails and other messages and didn't realize before we stopped that I'd received an email from one of the other judges. One of my colleagues, Judge Soifer, indicated to me in a note that she and Ms. Burgess are on a panel at the same CLE program I'm speaking at on Friday.
I hope she told you. I didn't want to prejudice the client in any way by asking for that. And so I had called her and asked if I could get, a substitute. And she said, well, let me talk to Judge Livingston first.
Apparently you're doing work in preparation for the others on that panel, and she doesn't want to lose your participation, I'm guessing. But in any event, I double checked that schedule because I was starting to prepare on Tuesday night for my own presentation on Friday. And in doing so, I looked at the schedule and determined that Ms. Burgess is scheduled to, with the other judge and others, to present from 9:45 to 10:30 with some allowance for setup. I'm going to call that 9:30 to 10:30. My session is from 11:30 to 12:15. So with prep, let's call that 11:15 to 12:15. There's a session and a coffee break between our two sessions, but practically speaking, Ms. Burgess is going to be out from 9:30 to 10:30, and I would be out from 11:30 to 12:30. So that's a huge break there from what we're doing. I don't know that we're going to be finished by Friday anyway, although I'm pushing to try to get that done. But that kind of blows our morning. So I think we need to start thinking about being more efficient in getting what we need done this week, but also we probably need to find another day to finish up whatever you're not going to finish up on Friday. So I say all that just to say, look at some calendars when we break at lunch. Maybe today we can spend more time talking about that. I don't want to take the time to do it now. I just wanted to give you a heads up so you can be looking at your calendars, and we'll have more time at the lunch break to talk about it. Ms. Dickey, what's the issue that you had to bring up?
Same issue, Your Honor, which is that we were considering it this weekend, negotiating between us and our co-defendant in terms of timing. And we would, at this point, given that the plaintiffs have spent almost 11 hours and we have spent 7 hours, like an allocation of time. Whatever time we're going to spend from now on, we would like half of it. I think it will make us all be more efficient if we know we're on a clock. If we have 2 days left, whenever that is, that's about 5.5 hours a day. We need time to make sure we get our witnesses on, and we all need to be more efficient. And I would request that the court give us an allocation of time from here on out so that we can budget among the defendants, and plaintiff can understand also that they need to budget their time. We've now had Mr. Saylor on the stand for going on the 3rd day. And we have some witnesses we'd like to get on. So we're asking for an allocation of time. I know that I try the court's patience with asking that, but it is very difficult for us to plan otherwise.
Well, I mean, I don't know how to respond to that other than to tell you that I've already allocated the time. I've already told you how much time you've spent. And I told you on Tuesday afternoon that you'd spent, the defense, 7 hours and the plaintiff has spent 10 hours and 50 minutes. I'm keeping track of it, but it's also a merits setting. This is all of you, really, your one and final opportunity to get your day in court. So, I'm keeping track of the time, and at some point I'm going to tell you you're out of it, or that you need to wrap up in the next hour or two. You should imagine that the plaintiff is going to get about 60% of the time, and you're going to get about 40% of the time because they have the burden of proof. They get to go first, they get to go last. I mean, that's generally how it works, right? Somewhere around 60-40, ish. But it's all ish because it's your final trial. It's not like I can just artificially stop you and say you'll have another bite at that apple when you get to your final trial. This is it. This is your opportunity for due process to work. So it's going to get finished however long it takes. And I realize that that's kind of a mixed message in that I'm saying, be efficient, but I'm going to let you go. But I am keeping track of the time. And so when we get to a point where I feel like you've used or they've used their allotted time from the 5 days I told you we were going to get, I was going to give you, at that point, I'm going to start to get draconian. So I don't feel like I have to say you have 4.5 hours left just yet, but I'm keeping up with keeping track of the time. I'm telling you at the end, I told you at the end of Tuesday, I will tell you at the end of today, and I'll tell you about tomorrow. But you know, it is what it is, and you get what you get, but feel confident that you'll have enough time to put on all your witnesses. You won't have enough time to waste time, either of you, but you will have enough time to get your case heard. And so you should not worry too much about that. All right, let's get to it.
I have a procedural issue. You'll note Anna Baker's here from Alexander DuBose. She reminded me that I did something wrong in terms of impeachment yesterday. When you read the screen from pages 101 to 112 of Saylor's testimony, that did not get to the record. And so we either need an agreement that we can make that testimony an exhibit and have it admitted, or make that testimony, allow the court reporter to have the transcript to add into the record, or we could, she said, read it. Ms. Baker suggested read it, but that seems like the least efficient of the options. I'm not throwing you under the bus, Anna. I know Ms. Baker's being as careful as possible. So we have that issue, and then we have the outstanding spreadsheets that Mr. Saylor produced, which are 310 through 355 and 357 through 402 that you were going to review, and hopefully we can get those admitted. One of them has already been admitted. That was 356 that we had pulled out separately, but this is kind of that bulk exhibit.
I heard about 3 things in there. Let's take them one at a time. First, with regard to the information that I reviewed silently the other day, it was in, if I'm remembering it correctly, which section of that you're talking about. I was either doing it to figure out whether or not there was an issue related to optional completeness, or I was either that or dealing with some issue of whether or not I thought that what you wanted me to look at was different from what was testified to in the deposition, and then to let you decide whether or not you could offer that additional evidence. Frankly, I don't remember which was which, to be perfectly honest. So you tell me. I don't have a preference one way or the other. If you want to offer sections or excerpts from the deposition, I don't, fine with me.
I would propose, if Ms. Baker could nod her head if I'm doing this right, I would propose excerpting 110 or 101 through 112 that you read and having it be an exhibit. That seems like the most efficient way.
Just to be clear for our record, you're talking about pages 101 through page 112 of Mr. Saylor's deposition? Yes, from October of this year?
Yes, Ron.
I don't have any objection to that. I did read it.
Ms. Baker, am I doing it right?
I don't hear any other objections to it, but I'll ask specifically, does anybody else care if we include those pages into the record just for a purpose? And I can't remember if it was optional completeness or if it was for purposes of impeachment or whatever, but for one or the other of those purposes, we'll ask the court reporter to include in the record a note that the court reviewed pages 101 through 112 of Mr. Saylor's October 2020 deposition, and they may be included in the record. All right.
And have you had a chance to look at the bulk exhibit 310 through 402?
Tell me 310 to 402. No, I have not looked at that.
That was the, we had one of the spreadsheets was already admitted and we thought they were agreed, but Mr. Soltero raised a relevance objection about the other many spreadsheets that Saylor produced to us. So we have asked that you.
So let me just be clear. These are plaintiff's exhibits, yes, numbered 310 to 402.
Minus 356 because you already admitted that one.
And you want me, I do recall that we were going to have some further discussion about it, but I didn't understand that I had a homework assignment. So I apologize that I didn't do it because I didn't know I was supposed to, but I do recall that we were going to talk more about 310 and 402. So you want me to look at that for what purpose?
We've moved for admission, and Mr. Soltero objected on the basis of relevance. These are the spreadsheets that Mr. Saylor produced back to us, the ranking spreadsheets that that we contend overlap with our spreadsheets, and so or our versions of our spreadsheets as he testified to. And so we asked that we move for admission of those. One of them is already admitted, but we didn't want to go through each one.
All right.
Literally forever.
Is there any other objection to plaintiff's exhibits 310 through 402 minus 356, which of course has already been admitted? Mr. Soltero, I understand from what I'm now being told that you have a relevance objection. Is there anything else you wish to argue about that before I take a look at those? I've not looked at them, I will.
Your Honor, relevance, number one, cumulative, and also, Judge, what we have an objection to is the just stuffing the record full of information that no witness is ever going to be questioned about, or that has been tied in any way to the case, and then at the last minute, kind of taking a snippet of one or two pieces and trying to use that. Relevance, it's unduly prejudicial to have that much unnecessary, irrelevant information in the record. And I understand that's not, those are my objections.
All right, I'll take a look. I do recall the discussion about the spreadsheets, but I'm sorry, I didn't understand that I thought we were going to come talk about them later when somebody pulled them up, and we were going to do that offline, but I'm happy to take a look at them.
And Your Honor, Ruffin joins that objection to the relevance and prejudicial.
Okay. All right, I'll take a look. I'll not likely do that before the lunch break because I won't have time to study those before then, but I'll try to do it then if I can. If I can't get it done over the lunch break, I'll do it after we break this afternoon. All right, let's finish up, Mr. Saylor, if that's at all possible. And if I remember correctly, Mr. Soltero, you were still asking him some questions. Is that right?
Your Honor, I had passed the witness.
Passed them? Oh, we passed them at that point for Ms. Burgess's redirect, which I told her I didn't think she could do in 15 minutes. And yeah, I do remember that. All right, very good. We'll start with then the questions by Ms. Burgess. Let me just make a note of the time. Okay, very good. I'm ready.
And Mr. Weisrod, if you could pull up F002, the first paragraph. Mr. Saylor, you testified, you're on mute, Mr. Saylor. The catchphrase of 2020, you're on mute, or the international phrase for that. So you've testified that 2012, when you came to Flow Sports, was different than 2019 because in 2012, Martin Floriani really needed you, right?
Yes.
Okay, and in 2019, Mr. Floriani really needed you, right?
Sometimes she said so.
In fact, in this first little snippet of the flywheel letter 002, he says need, I think 4 times, right?
I need someone. Is what I said.
And if you scroll down, Mr. Weisrod. And in fact, he's talking about working with you, correct? He says, I'm intrigued. It would be special to team up with you again, right?
Objection, the document speaks for itself.
Sustained.
Mr. Saylor, are you denying he was saying he needed you to come work for him?
Same objection.
Overruled. I think the question here is whether or not he was talking about needing someone in particular, like Mr. Saylor, or needing someone in general. And so the question is simple, Mr. Saylor. Did you understand this communication to mean that he was specifically saying he needed you versus he needed somebody, generally speaking, to do this work?
At some point, yes.
Okay, and let's talk, you can take that down, Mr. Weisrod. Let's talk about the National High School Coaches Association. You testified that you knew that even though you suggested it in that first letter, as well as in several texts, that you knew that wasn't feasible, correct?
Can you rephrase the question?
Sure. You brought up flipping the National High School Coaches Association in that first FOO2, the flywheel email, right? Yes?
I brought up NHSCA on a couple occasions, yes.
Okay. And then in at least a couple of texts, right?
I think so.
And you said you knew that wasn't feasible because you knew their contract terms with Flow Sports, right?
I knew that they were signed. I knew that they had a contract for a long time, yes.
And in fact, you said on Friday, you said you knew the terms of the contract with Flow, right?
No, I don't know the terms other than the length. I mean, I did at one time know the length.
So if you said that in your testimony, you're saying you just misspoke?
What if I knew the terms? The only terms I knew, and I think that I knew them, is that
And please don't tell us the types of terms, not what the terms are, because that's not publicly
Your Honor,
available.
I object to the counsel interrupting the witness when he was answering.
I just don't want him to.
She was trying to advise him not to divulge something that might be confidential. So she's just alerting Mr. Saylor that it's not necessary for him to divulge the specific things he knew or didn't know, just whether he knew or not.
right. The only thing I knew or know today about the terms of that agreement was the length of time.
Now, Mr. Saylor, the reason that you were suggesting that is that you thought that it would be a good idea for that event to go to Rockfin, or their events to go to Rockfin, right?
I did when I had a sort of misunderstanding of what the platform was.
And that's because you think competition is good, right?
Well, no, that's not why.
Well, you thought it was a differentiating of options, have a different option than Flow Sports, right?
Yeah, it's a very different model. Yes.
Okay, but two options for the same rights holder, right?
Well, there's many options. Rights holder.
Well, let's go to, can we go, Mr. Weisrod, can we go to the deposition? I'm gonna take y'all for counsel to 201, 1 through 5. The fact is that you think that competition is good and that this was a differentiating of options for that same rights holder, correct?
I think that people should have, I think that people having a lot of options to do different things is good for society.
And Your Honor, I object this as improper impeachment. The question begins on page 200, line 21, and they're only showing a part of the discussion and answer.
I don't think we need this displayed at all because his testimony is not thus far, at least, inconsistent with what this says. So let's just move on.
And that's what differentiating of options for the same rights holder in two different places to live stream. That's what happened at Nittany Lions as well, correct?
Objection calls for speculation.
Sustained.
Now, you know that Nittany Lions was broadcasting live events, is broadcasting live events that you can see exclusively on Rockfin, correct?
Yes.
And They could have gone to Flow Sports, correct?
Objection calls for speculation.
Sustained.
Well, you worked at Flow Sports for 8 years, and certainly you've alleged many times that Flow Sports' core business is streaming live events, right?
Overwhelmingly, yes.
And so Flow Sports likes to get rights from people who stream live events, correct?
Yes, I think I've previously testified that I had heard that they were shopping it around to a bunch of channels.
And there's no question that Flow Sports had the capability to stream the Nittany Lions events, right?
Sure, yes.
The only difference between the NHSCA and Nittany Lions is that NHSCA has more events, correct?
Objection vague.
I'll sustain that one. It's not when you say if they have, meaning whether or not they sponsor, whether or not they stream, whether or not they make deals with platforms, that in that regard, it's
NHSCA has even more, is an even bigger rights holder than Nittany Lions, correct?
Well, they do not have as many events as Nittany Lion does. And it would bigger rights holder, you'd have to define that. I don't know, in terms of what?
Both Nittany Lions and NHSCA stream live events, right?
Yes.
Now, let's go to F-160. Particularly 3B, the top part of 3B. Mr. Saylor, you testified that that a lot of people at Flow Sports pursued you to get your signature on this PIIA, correct?
A lot of people, I said the office manager asked me to give it to her, where it was, or have you signed this? The office manager asked me that.
She came around several times, right?
2 times, I believe.
Okay, and then, I'm sorry.
If I recall correctly, it was like 9 years ago. I think she came around twice.
And ultimately, you knew you were going to have to sign this, right?
Well, that's what I was deliberating on. I don't know. Define
You made a
have
choice.
to. I don't know.
You made a choice to sign it, right?
I made a choice to sign it when I was told what it meant.
Now, so is it your understanding that Flow Sports made repeated efforts to get you to promise to do something you never did?
The office manager asked me to turn in a piece of paper. What do you mean to do something I never did?
Well, if your understanding is that this is tied to only live events, is that what you've testified?
I testified that it was explained to me. I said, does this mean, this piece of paper mean if I leave or get fired that I can't work in wrestling for 1 year? And I was told, no, this is for the live sports video industry. We just signed a live sports streaming company, and we don't want our employees learning the ins and outs of how we stream stuff and taking it to somewhere else and starting their own thing.
I need to object to non-responsive. I don't want to inadvertently bring
overruled. You asked him the question. He's provided an answer. His answer stands. Let's move on.
You permitted the question about his understanding previously from in the direct. So, but you thought that Flow Sports was making these repeated.
Yes, because in the direct, you made an objection that was at that time timely. Here, you've opened the door by asking him a question. So if you ask it, he gets to answer it. Be careful about what you ask.
I'm not opening any doors, Judge.
I appreciate that you're not trying to, but whether or not you actually do is a different matter. So let's move on.
Mr. Saylor, is it your testimony that that you thought this document didn't prevent you from doing what you actually did?
Your Honor, I object to that as vague.
Sustained.
So Flow Sports wasn't asking you to refrain from what you actually did?
Objection vague.
When?
Sustained.
So when you understood that you had a non-compete, you thought that applied to things that you didn't do for Flow Sports?
Your Honor, I think that's argumentative and cumulative.
I join the objection to add vague.
Overruled that.
Can you just, for clarity, I think I know what the question is. Can you say it again, Ms. Bridges?
Sure. So you testified in response to your lawyer's questions that you understood this to be limited. Are you testifying that you thought it was limited to things that you never did for Flow Sports?
No, I thought I could do wrestling journalism. I was very much understood that I could not live stream things.
But you did live stream things when you quit, right? You immediately put up Why I Left Flow, correct?
It's not a live stream.
Well, you had podcasts, right?
Podcasts aren't live streams.
Okay, so there's something about this document that made you think that the only thing it prohibited was live streams?
Yes.
And in number 1, when it says that you won't compete with the company without any reference to the business of the company, that doesn't say anything about live streams, does it?
No, I don't believe I am competing. I believe I'm doing journalism.
You're doing exactly what you were doing at Flow Sports, aren't you?
No, I am not. Not even close.
Let's go to 10.2. And at the very bottom here, you talked about how your duties changed at some point. 10.2, in 10.2, you agreed that the validity of this document would not be affected by changes in your duties, correct?
Your Honor, I object. This calls for a legal conclusion. The document speaks for itself.
Well, she can ask him what he understood this provision to mean, but I think you'll have to ask him a little clearer question because I'm not sure I followed it.
I probably need to show him the next part of 10.2 as well. Mr. Weisrod, would you mind going to the next page and showing the other part of it? You testified in response to your lawyer's questions that the non-compete, something about the non-compete would have changed because you changed jobs, correct?
I apologize. One more time.
Sure. You're not taking are you taking the position in this case that the non-compete's validity is impacted by the fact that you chose to move to Pennsylvania and have a different title?
No, I'm
you can take that down. Thank you. Now, I recall that in response to your lawyer's testimony, you said that the rankings that you took off of Flow and then gave back to Flow were not the same, right?
Well, that's two different issues.
Okay, the rankings, things happened between the day you took them off of Flow Sports CMS and the day they were reposted, right? Events happened, wrestling matches.
They weren't the same thing.
It was the same. What were they called?
Objection vague as to they.
Sustained.
What were the rankings called, the first set that you took down off of the CMS?
The rankings that I took off the CMS were called I don't know. I believe it was a big board or a crystal ball rankings.
And what were they called when they went back in?
Objection vague.
Well, I don't know that it's vague, but it assumes a fact, not an evidence. I think. So let's get a clearer question.
Mr. Taylor, did you testify previously that ranking, well, you've already testified that you took down rankings from Flow Sports and explained to Mr. Piles that you gave them back, correct?
Well, I took down two things. I took down two things from Flow because they hadn't run yet. They hadn't been circulated. They hadn't been promoted. It's like, yes. So that, but the category, the characterization of that, I gave them back. They were never gone from Flow. There was never a time I took them off the CMS, but Flow had them the entire time.
You took them off the CMS and you put them on Rockfin CMS.
No, never happened. I don't know how you keep coming to this conclusion.
Okay, when you told Christian Piles that in text, were you lying to him when you said you gave them back?
What I meant by gave them back was I told you where they were.
Oh, okay, so you're saying they were somewhere in Flow Sports Google Drive, but they weren't on the CMS. They weren't showing to the public.
That's right.
Okay, but rankings with the same name showed up on Rockfin by you within days, right?
4 or 5 days, same title, different material, different analysis.
The only thing that changed in those were things that happened in between those 2 dates, correct?
About a week of worth of results, yes.
Okay, but otherwise it was a version of what you started when you were at Flow Sports, right?
Every rankings is a version. I mean, rankings happen, results occur, and then you.
Overruled. Go ahead.
So every rankings is a whiteboard, right? The college football rankings come out this week, and Texas is number 3, and then Texas gets beat, and they move to number 5. It's like using a whiteboard every week.
Now, the spreadsheets, I'm going to go from rankings to talking about the ranking spreadsheets, okay?
Yes, ma'am.
The spreadsheets that you kept,
Spreadsheets.
right? You currently keep spreadsheets as well?
I have spreadsheets, yes.
When you were at Flow Sports, you would add and modify and update them, right?
Yes.
And you would refer to them when you were creating content to publish on Flow Wrestling, right?
I would refer to them. What was the?
You would refer to the spreadsheets when you were creating content on Flow Wrestling.
No. Refer to the spreadsheets?
Right. I mean, that's where you went to get data.
Well, there's no data in the spreadsheets. And also, why would I refer to spreadsheets in an article? Why would I say?
I'm sorry.
In my spreadsheet?
I mean, I was confusing. What I'm saying is you use them to help you with your work at Flow Sports. It was a tool in your work that you created.
I don't know what the question is.
Sure, you entered a lot of data into these spreadsheets, right?
No, there's no data in the spreadsheets.
I'm sorry, you testified previously that there are thousands and thousands of cells in these spreadsheets,
Thousands
correct?
and thousands of cells that say freshman, Miss Burgess, Austin, Texas. There's no results in there. There's no whatever.
There's no results in the spreadsheets?
There's just a list of names.
So you created dozens and dozens of lists of just names? That's what you're saying? The spreadsheets don't have any data?
The spreadsheets look exactly like what the rankings look like on your website or anybody's website.
Okay.
The only thing
356.
The only thing that I once in a while do that doesn't face outwards is sometimes in my worksheets, I compare what they're ranked on intermat and track wrestling. I compare all the rankings just to make sure somebody doesn't have a guy number 5 that I totally just spaced it on. Other than that, the spreadsheets look exactly, the worksheets look exactly like what the public sees.
Let's pull up F401. And while he's doing that, Mr. Saylor, do you recall testifying on Friday that we looked at 101 cells that were publicly facing, and then after that, the folks who didn't make the big board and that was not publicly facing? Do you remember that testimony?
Yeah, for other guys that I recognize as people to consider.
Right. You're not telling this court that everything in the ranking spreadsheet showed up on the Flow Sports website.
Other than people that didn't get in, I would describe them as, I refer to them as honorable mention kids.
Okay,
We object to this spreadsheet, which is not in evidence, being on the screen.
Okay, are you familiar with this is one of the ones in the bulk.
My space bar is sometimes working and sometimes not to temporarily unmute, so I apologize. 401 has not yet been admitted. It is within the range of ones that you all wanted me to look at, but and she's entitled to show it if it's not confidential in order to have him try to prove it up. Is there an objection to 401 other than the ones that were urged as part of the cumulative objection? This one apparently is being called out separately. So with regard to this specific exhibit offered by the plaintiff, is there any objection?
Objection, Judge.
No objection.
Okay, I wasn't sure what you said, Mr. Salter. Did you say no objection?
That's right, Your Honor. No objection.
All right. Plaintiff's exhibit number 401 is admitted.
And we cannot pull it up, but let's just have Mr. Saylor. Do you have 401?
I can't even pull it up. I'm
It's
sorry.
not listed as confidential on my exhibit list. If it is, it's not listed as such. So, and now that it's been admitted, unless there's an objection to displaying it publicly, you can put it up if you wish.
I'd rather not. I think that it contains confidential information.
All right. It's not marked confidential on my sheet, but that's fine. And if Mr. Saylor, if you have a copy of it available to you, if you don't mind, please looking it up so she can ask you some questions about it.
It's 401, yes?
Yes.
And I'm not looking for it, but is it the list of world placers or world team members?
World, it is.
It's world team members, right? They're not rankings.
This spreadsheet includes a lot of data points, doesn't it? Not just their names.
The only data point that it includes is what their finish was at the World Championships. That's the only data point other than name and state.
Where they're from, right?
They're also not rankings.
And it's got how they finished on these, right?
Yes, it has name, state, and how they finished at the World Championships, but they're not rankings. I don't even know if.
And there are 1, 2, 3, 4, 5, 6, 7 different tabs here.
Well, I don't. I still couldn't find.
And these are. I'm sorry, you can't tell how many tabs.
I'm sorry, Ms. Burgess. I haven't.
You're probably not seeing the tabs because the way your box works. It's okay.
No,
but
I haven't found the document yet. I'm sorry. I'm just answering off memory.
Oh, okay. Well, the data that's in these spreadsheets are things that you entered in as part of your job over the course of 8 years at Flow Sports, correct?
I wouldn't say that at all because that was not used for anything.
I'm sorry. You did that as part of your job at Flow Sports, right?
Not really.
So you created 7 spreadsheets that have probably 1,000 cells filled out for no reason?
Well, I'll say this. Well, yes. The short answer is I never used that information for any content ever produced.
Well, then why did you recreate exactly the same spreadsheets about old data when you left Flow Sports?
Excuse me?
Well, you testified previously to this court that the spreadsheets you produced to us were not merely versions that you modified, but that you had recreated them, right?
I recreated several things, yes.
Okay, so with regard to this one, there's thousands of cells filled out, and you're saying it wasn't used for anything, and yet you recreated it when you got to Rockfin?
Yes.
And you even put the same mistakes in your spreadsheets, didn't you?
I don't know.
Did you copy from the original? Are you saying you didn't copy from the original one?
I'm saying that I don't know. I don't know if that one was one that was recreated.
But you just still had it? Is that what you're saying?
Yeah, I perhaps had that one.
In fact, you downloaded 69 spreadsheets in late October of 2019, correct?
Not true at all.
Well, they were on your laptop, weren't they?
No.
Okay. How did you have them when you sent them back to us?
Your Honor, I object. This is, wait a minute, Mr. Saylor. This is really a discovery issue. In connection with our discovery obligations, we did a deep search of everything, and she's asking a witness, I would say, foundation and relevance to all this.
Overall,
The spreadsheets, the way that they're organized, hold on just one moment. The spreadsheets, the way that they're organized, you created that, right? You created how they would be laid out, correct?
Objection form vague. Which spreadsheets, Judge? Is she talking about this particular exhibit or all of them?
sustained.
I mean, I guess I would. Sorry.
Oh, I'm sorry. So let's just take 401 for an example. And Judge, I am concerned that one of the objections to these was that it was a bulk exhibit, and for efficiency, it seems like I should not go through 100 of these spreadsheets with Mr. Saylor, but I can if that's how I need to get them in.
Well, the question right now is, are you asking him about 401, that spreadsheet, or 356, a different spreadsheet, or are you asking him about the spreadsheets that have yet to be admitted? I think that's what Mr. Saltero is confused about in terms of the vagueness objection that I sustained. So it's just as a matter of, are you asking him about those two that are admitted, or are you asking him generally about spreadsheets? It's just not clear which question you're asking him. And once we get that clarity, then we'll see if there's any objection. But right now, we just don't know if you're asking about the ones that are in evidence or the ones that are not yet in evidence, but that haven't been offered.
Yes, Your Honor, I'm asking about generally, Mr. Saylor, generally these spreadsheets, and there's 100 more that we've offered. Did you create the structure for those spreadsheets?
I finally just, I'm sorry, I finally just pulled up 401. Anyway, did I create the structure? Yeah, I mean, the first time, nobody's ever taught me how to do anything with rankings. So I guess from the beginning of my career, I just made it up as I went, I guess.
And the spreadsheets that you had at Rockfin have the exact same structure, correct?
Check to the form assumes facts not in evidence. There's no evidence he has any spreadsheets at Rockfin, as she asked.
Sustained.
The spreadsheets that you currently are using have the exact same format, correct?
That's false. As a matter of fact, the columns are in different orders, and that somehow the columns in the different orders appeared on your site well after I published them at Mat Scouts. So that's interesting.
Oh, you're talking about the rank. You're talking about the rankings themselves, right?
Yes, and the column.
I'm sorry, Mr. Taylor, I'm talking about the ranking spreadsheets. They have the same title, correct?
Oh, no, not all. Title?
They have the same column names, correct?
That's the title of the spreadsheet is totally different than the names of the columns.
Okay, the spreadsheets, those compilations that are in the spreadsheets, the compilations of data there, those have never been made public, have they?
Your Honor, I object again, vagueness as to which spreadsheets. If she's talking about 401, one thing, otherwise vague.
I think well, I can't tell, and so I'll sustain the objection because I can't tell if you're asking generally about spreadsheet information or about these two. If you could just clarify that, I'm going to let you ask him, but I need to know if you're asking about these particular ones or generally about spreadsheets.
I'm asking generally about spreadsheets. These spreadsheets, these compilations, and you actually testified about this Friday afternoon, that these compilations had never been made public, correct?
I have no idea what you're talking about. Compilation?
Well,
It would be helpful if you stop referring to other testimony. Just makes it harder for him to follow, and it has to ask him to go back to 3 days ago. It's not helpful. If you want to just generally ask him if the information that he used, created, consulted, included in spreadsheets generally were publicly available, I get that question. If you want to ask him about whether the information in spreadsheet marked as Exhibit 401 or Exhibit 356 was made public, I get that question. The problem with your question is not about the substance of it in terms of spreadsheet information being public, but rather if the question is a specific reference to a particular exhibit or to spreadsheets in general. And that's the issue that I'm having. And that's what I'd like for you to clarify without reference to any of his other testimony. That testimony is in the record. So just ask him today, if you would, what question you want him to answer today.
Mr. Taylor, you never put, let's just take for instance 401. You never put 401 on the internet, did you?
401. Not to my recollection.
Okay. Do you know anyone other than you and Mr. Lobdell who may have helped, may have accessed it? Do you know anyone else who has access to that?
Objection assumes that's not in evidence.
Let me ask a better question. Do you know anybody other than yourself who's ever seen that who didn't work at Flow Sports?
Who didn't work at Flow Sports?
Right.
I mean, it's on, that spreadsheet's on Flow's drive. So, no.
You're right. It is on Flow's drive and you produced it back to us, right?
Right.
Okay. Let's go to F665. I believe this is already admitted. Okay, and can you see here that I think, is it page 2 that has the 71 minutes? Page 2. Can you go to page 2, Mr. Weiserot? Can you see at the bottom where it says comprehensive attribution right there?
Yes.
Okay, and is that the spreadsheet you accessed on the 3rd of, or the dashboard you accessed on the 3rd of November?
Yeah. Yes.
Is that the one you usually used?
Yes.
And which one has the 71 minutes? Is that the first page? No. Oh, okay, now I need F666. Okay, and can you see, I believe it's 71 minutes over there on the right on the 3rd of November. but it's got, you can just tell that it's between 60 and 80, right? Something over an hour you spent there.
Well, I think that's a little misleading, but yeah, that's what that's the numbers that it says.
Okay. And Periscope, you agree, contains some of Flow Sports' most sensitive information, correct?
Objection asked and answered.
I can move to a different question.
I'm just trying to get my space bar to work. The objection.
It's really, no, it's loaded.
Excuse me, we've been over this
Right.
quite a bit. And so I want to give you an opportunity to ask questions, given his testimony to others the other day, but you've asked him these questions before.
Well, and Mr. Saylor, there's a lot more information on this dashboard than just attributed subscribers, isn't there?
Yes.
In fact, there's, you can see new and reactivated. I'm sorry. Oh, can you take the exhibit down, Mr. Weisrod? When you look at the comprehensive attribution dashboard has total new, shows new and reactivated subscriber signups, doesn't it?
I don't recall what it has in there.
Can you deny that it shows total upfront and net to cash for a given vertical?
I don't recall all the details of what's in Periscope. What I accessed the last time I accessed this was over a year ago.
Do you recall that it had that it has sign up forecasts for specific events?
Are you going to ask me all the category? I don't know. I don't remember what's in there.
Okay.
I do know that you can download all the data that's in there with a click of one button.
And did you download the comprehensive attribution spreadsheet?
No. And if someone wanted that data, they could do it with one click of a button, which 90 minutes, it's silly.
Well, let me ask you about that. Anybody who was in there had a password, right?
I don't know how it was set up. I don't know.
You used a password to access it.
I don't know.
Well, you had a confidentiality agreement.
What was that? Yeah. Yes, I had a confidentiality agreement.
In fact, Mr. Floriani frequently talked about how important and secret the data in Periscope was, correct?
Yes.
Now, you talked about the impact that this lawsuit has had on you, correct?
Mm-hmm. Yes, I have.
And you saw some text with Christian Piles where he said, you keep making, well before the lawsuit, where he says, you keep making this hard on me. I don't want Flow Sports to have to sue you. Do you recall that?
Christian said that?
Right. He said, we'll go and stand down, except that you keep taking rankings and going to Rockfin to compete, correct?
Christian told me before that that it wasn't about me, it was about Martin.
Objection non-responsive. He told you you're making this hard on me, didn't he?
I don't.
Objection, the document she is referencing speaks for itself.
To the extent that you're asking him about written correspondence, I'll sustain the objection. If you want to ask him about his in-person or telephone or verbal conversation with Mr. Piles, you may do so. I authorized that exchange last week. It's just not clear what you're asking him, and it's not clear what he's testifying to versus what you're testifying to. So again, just ask him a question. That requires nothing other than the knowledge in his head, unless you want to show him a document, in which case pull it up. But it's very difficult for us to follow this, or at least for me to follow, because I don't know if you're asking him to remember something he said on Friday, or if you're asking him to remember something that happened a year ago, or if you're asking him to remember an exhibit that has been admitted. It's just not clear from your question what you're asking him about. And I think that kind of clarity would be helpful.
Mr. Saylor, you and Christian Piles talked extensively about the fact that he would like for Flow Sports not to sue you, right?
He said that they weren't going to sue me.
And he said, just don't go compete at Rockfin, right?
No, that's not. He never said that.
He said, don't take down rankings,
Actually,
right?
he didn't say don't take rankings spreadsheet. No.
I'm sorry, don't take rankings off of Flow Sports and post them on Rockfin, correct?
No, he didn't say that. As I admitted, this was a mistake on my part. I took down 2 things that hadn't run yet. I thought to myself, I left. Why should they run on Flow after I'm not even employed there? He said you took them down. I said, you're right. That was a mistake on my part. Here they are. This is where you can get them and put them back up. Okay. Then a couple days later, I said, hey, maybe I can still do stuff on Flow. And he said, you're making it hard because you already put some stuff on Matt Scouts.
That aired on that was shown on Rockfin, right?
Yes.
And let's look at F079, which is a demonstrative. Mr. Saylor, you didn't even try to find a job that didn't compete, did you?
Object to that as assuming facts, not in evidence.
I object to argumentative.
I think it's argumentative. I'll sustain that one.
When Mr. Saylor, when you say this lawsuit has been hard on you, did you try to find a job that wasn't at that didn't air things on Rockfin?
I'm confused as to the time frame. At what point when you say try? And I'm asking that given the testimony about the UNC position. So I guess I just don't understand your time frame. Do you mean after he left Flow Sports?
Right.
Before he decided to leave? It's not clear to me when you're asking him about.
First of all, Mr. Saylor, Flow Sports did not say they were going to enforce a non-compete with you at UNC, correct?
They did not say that. No.
Did you, after you quit on the evening of Saturday, November 2nd, did you make any effort to find a job other than taking a job as an employee at Rockfin?
No. Are you suggesting that I could have worked?
I'm going to object to that.
Except for Rockfin?
Mr. Saylor, if you don't understand her question, just let me know you don't understand it. I'll ask her to rephrase it. But if you don't know the answer, you can tell us that. If you don't understand, you can tell me you don't understand. But I don't want you to guess at what you think she's asking, and I don't want you to volunteer information that she's not asked about.
Apologies. Ms. Burgess, can you ask the question?
Sure. Mr. Saylor, you quit on November 2nd in the evening after Mr. Floriani had been in Pennsylvania the day before, correct?
You've asked him that question 3 times. What is the next question you want to ask him about that gets to the heart of this issue? We have been over that testimony. It's no reason to set it all up again. Everybody's familiar with the time frame that's been testified to. What is the bottom line question you want to ask him right now?
Well, you asked me to clarify the time frame. I'm saying after that, is that
clarify if you're asking him if he made efforts to find a job that he thought was competitive before he quit or after he quit. That's all.
Did you make any efforts to find any other job than Rockfin after you quit Flow Sports?
Sort of. I mean, in the sense that I have been thinking about other places, other avenues to work for years. And of course, with the contentious relationship with people I worked with, and you guys.
I'm going to object to non-responsive because I was talking about a particular time frame.
Just state the objection. Don't need to further explain it unless I need to. Mr. Saylor, I realize that it's sometimes difficult to follow here, but I'm going to ask you to just answer the specific question that you're asked. And this one's pretty simple. Yes. Before you left, after you left, did you do X? Did you do Y? That's it. No more than that. So I'm going to ask Ms. Burgess to re-ask her question, and just if you would please answer that question only. Ms. Burgess.
Sure.
After you quit Flow Sports on the 2nd of November, did you make any effort to find a job other than going to Rockfin?
No,
Before you left Flow Sports on November 2nd, had you made any effort to find a job other than UNC?
yes,
Okay. And was that in the coaching arena?
sometimes.
Okay. Had you, when you left, when you quit, did you try to find a coaching job?
Your Honor, objection asked and answered.
Overruled as to whether he pursued coaching opportunities after he left Flow Sports after November 2nd. You can answer that question.
I'm sorry. What was the specific
I'm
question?
asking whether after you left Flow Sports on November 2nd of 2019, after that date, did you pursue coaching opportunities? Yes or no?
No. And let me be clear. I mean, I think
I'm going to object to non-responsive. That's good enough for me.
I think no is a clear enough answer.
Your Honor, we object to this demonstrative from the opening statement being displayed on the screen.
I was going to ask about it myself. It's not marked as an exhibit. So if you have a question about it, since you're not offering it, and if it's an agreed demonstrative, I don't have any objection to it. But I
Not
don't
an
know,
agreed demonstrative.
I don't know what its purpose is at the moment.
Judge, I'm going to ask a question about it. It was shown in the opening.
Anything that you showed in the opening statement is okay.
All right, let's go back to that. So how many subscribers do you have today on Rockfin?
I'm not sure.
Well, you testified it wasn't 5,000, right?
That's correct.
But you don't know how many it is even roughly?
Ballpark. I mean, I know that it wasn't 5,000 because that is insane. That's not even close. I think it's roughly around 1,000.
Okay, so you had the subscribers at Rockfin just about doubled the month you joined, right?
I can't say with any certainty.
Well, and then the Nittany Lions event was very successful as well. You got subscribers from that, right?
Ms. Burgess, if you have a question about this document, you may ask it. Otherwise, take it down. If you have a question about it, what is it?
Right, that's what I'm asking. That event was September 2020 was when the first Nittany Lions event was, right, Mr. Saylor?
Yes.
And we can see a big spike at that point, correct?
Well, I don't know that we can see a big spike because this is not a document that's in evidence. So if you're asking him to confirm some information on your demonstrative only exhibit, that would obviously be inappropriate. So let's just take this one down. It clearly is not of any use for purposes of testimony. So let's take it down and you can ask him your next question.
Well, Mr. Saylor, you've seen that publicly facing dashboard on Rockfin, correct?
Yes.
Okay, and you got subscribers out of the Nittany Lions event, didn't you?
Objection asked and answered. Yes, Tuesday.
Sustained.
Now, Mr. Saylor, you have made a great deal of Ray token off of your work at Flow Sport, at Rockfin.
Objection relevance.
Overrule the relevance objection. Don't know yet whether it's relevant with regard to the damages. I can't tell. So I don't know though that if unless it's relevant to something other than damages, I don't know why we would be talking about it now since we're going to be talking about damages later.
So Mr. Saylor testified about the impacts of this litigation on him, but he's made a great deal of money off of it. And so it seems that would be appropriate to the effect testimony.
I don't know what to do with information about he's made a great deal of money off of it. A, I don't know why if he made money off litigation, it would be relevant. B, I don't know what that has to do with damages that your client may or may not have sustained as a result of actions that he took, which are alleged to have been violative of some agreement before the litigation started. The logic of that statement eludes me. So If it's relevant for some other reason other than damages, you may ask about it. Otherwise, let's move on.
Now, Mr. Saylor, you've talked about the effect of all of this. The fact is that you've made more than you ever made by violating your non-compete, correct?
Objection, argumentative.
Relevance.
Sustained.
Mr. Saylor, you have been well compensated at Rockfin, correct?
Objection, relevant.
Sustain the objection.
Okay, let's go to 098. It's another demonstrative that was used in the opening. Mr. Weisrod is F098. Now, Mr. Saylor, you have said that Rockfin is content neutral, correct?
No, I didn't say they were content neutral. I mean, I don't even know if this is, I don't know if this is material, but what I said was they were content agnostic.
Okay, well, you know that in order to join Rockfin, you have to be pre-approved, correct?
Objection, lacks foundation.
Sustained.
Mr. Saylor, you had to be pre-approved and you came to Austin to have the Rockfin folks get you onto Rockfin, correct?
Objection, compound.
Well, I don't understand the objection. He already testified that he came to Austin. Whether or not he came for the purposes of some sort of pre-approval, I don't know. You can ask him that question.
Mr. Saylor, you came for the purposes of learning how to use the content management system, correct?
I went to Austin to learn how to use the content management system, yes.
Okay, and is it your testimony that you don't know that you can't just log in and become a Rockfin content provider? You didn't know that?
When did I say that?
Well, can you just log in and become a Rockfin content provider?
No.
Okay, Rockfin has to let you do that, right?
Objection,
I think how I understand it is you apply and they say thumbs up or thumbs down. I don't know. I don't work for Rockfin and I don't know how the process, I don't know intimately how it works.
But originally you were hired as a W-2 employee to recruit content providers, right?
objection, argumentative, asked and answered, assumes facts not in evidence.
The asked and answered objection is sustained. This is completely repetitious, Ms. Burgess. It's a repeat of what we have been over many times in questions that you asked, as well as in questions others have asked. Not new information. Today, we only have time for new information, so please move on.
Okay, is there anything on this list that is not something that was a condition or a part of your work on Rockfin?
Your Honor, I object.
Objection.
Go ahead, Ms. Klingzeisen.
Well, that is just a compound question. It asks 12 different questions.
Your Honor, I would further.
No, stop. Hold on. That objection's overruled. Mr. Sotero?
Yes, Your Honor, I think this is all cumulative. And what I would say is they're taking a demonstrative and asking questions that have already been asked, wasting everybody's time to try to be argumentative. So on those grounds, I would object.
I'll sustain that one. It's asked and answered.
Right, they've all been covered. All right, pass the witness.
Mr. Saylor, do you have available to pull up F356?
Still going, huh? F356, yes.
Okay. Until Tuesday, in the time period between you left Flow Sports and Tuesday, have you looked at this spreadsheet?
I don't know what this spreadsheet is.
Okay, let's start with 401 then. I know you have that up. In the time period between when you left Flow Sports and today, Have you looked at that spreadsheet for your work at Math Scouts?
Can I correct myself on the previous statement? Because I can guess what that 356 is.
Well, we pull it up. I'd ask you that you answer my question on 401.
401.
Have you used the spreadsheet that is labeled F401 for anything you've done at Math Scouts?
Objection, leading.
Overruled. You can answer that question.
No, I haven't looked at that spreadsheet, and I don't know when's the last time I looked at that. And as I said to.
Okay, and what about 356?
356, that is dated. That thing is old.
Do you have in your rankings work, do you have any use for data from 2013, or excuse me, for the names of wrestlers and the other information from 2013?
Objection, leading.
Oh.
Do you or don't you? You can answer that question. Do you still have that or not?
No.
I pass the witness.
Very briefly, Your Honor, just a handful of questions. Mr. Saylor, in responding to discovery in this case, did you or did you not grant your lawyers access to produce whatever was found on your Gmails?
I grant it. Yes, that's accurate.
Putting aside whether any document may or may not have been produced in response to discovery, are any of these spreadsheets that have been raised something that you've used in connection with your work since you've been at Math Scouts?
No, sir.
Is there a difference between your spreadsheets and the spreadsheets that you may use while you were at Flow Sports?
Is there a difference?
Can you explain for the court the difference, if any?
I changed some things about the formatting and stuff. I mean, there's not much difference. I mean, all rankings are I would assume that all rankings spreadsheets are gonna look similar because they contain, now I know a lot of people who put results in their spreadsheets. I've never have. I don't know that anybody at Flow has ever have, except the guys that did the college rankings. They all had results and stuff in theirs, but I don't know.
No further questions, Your Honor.
Nothing further, Judge.
Thank you, Mr. Saylor. Ms. Burgess, you may call your next witness.
Yes, point of call is Christian Piles. We just need 1 second to get him in here. Hold on.
Your Honor, may we add argument on the bulk spreadsheet admission that's pending?
Yes.
Okay, I'd just like to say that
Hang on, is Ms. Burgess gone to get somebody? There she is. I see her. Go ahead.
well, we'd just like to add that each of these spreadsheets is different and unique. And as we just saw with Mr. Saylor's testimony on 401, each one would depend on what he had to say about them. And for that reason, we don't think that's another reason why we don't think they should be admitted in bulk without his testimony supporting them, just because the argument is that he produced them back to.
Right, I'll take a look at them, and if I need further argument, I'll invite it after I've had a chance to look at them. But as I told you this morning, I've not done that. I will do that sometime today.
Okay, thank you.
Judge, if we did need that, we would need an opportunity to recall him to ask him about the 100 spreadsheets. So that, but yes.
Has Mr. Piles joined us?
We need just 1 second for technology, Judge.
Well, is he ready?
Now
Okay,
we're here. Yes.
I've got to give the court reporter a break here anyway, and since they're changing things out, it might be beneficial to let them do that now as we start a new witness. But before we leave, I just want to know how to correctly spell Mr. Pyle's last name. Is it Pyles or Piles?
PY, Judge. PY.
Thank you. All right, let's resume at 10:30 and we'll be ready to go there and we'll switch out
Thank you,
our
Judge.
technology as well. Let me recess until 10:30.